Go live button. So let's wait for the stream to fire up all across these fruited plains of the internet. Then we're going to get started. YouTube always takes a quick couple seconds, but it looks like we're live. So let's get rocking and rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. And that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of finding justice. And we're grateful that you are here and with us today because we've got a lot to get into. We're going to revisit some of the Capitol Hill cases. We've got two defendants, last names of Tanios and Khater, who had court today trying to get out of custody. They're still in custody. Remember, this all took place back on January 6th, or kind of the January 6th riots. And we have two people who were charged in connection to that event and more closely connected to Officer Brian Sicknick's assault and sort of tangentially his death, even though now we know that he died of natural causes, nothing to do with the alleged assault. So these two gentlemen are now being charged with crimes. They're being housed in federal detention centers as we speak. They had court today to try to get out of custody, given the fact that we now know that Sicknick wasn't actually killed by them. We're going to see what the judge has to say. Are they going to get out of custody or not? So we're going to go through what happened in court, have some updates on some of these Capitol Hill cases. Then we're going to change gears. We're going to talk about a 73-year-old woman, goes by the name of Karen Garner. In 2020, she had an interaction with Loveland law enforcement, which is a town in Colorado. 73-year-old woman apparently had dementia and some other mental disabilities, and she had her basically arm jerked out of her socket. You can see it right here in our thumbnail. Take a look at that. So we're going to go into that story and let's see what the police have to say for themselves. Now, the family, the Garner family, has initiated a lawsuit for civil rights violation, seeking all sorts of compensation and damages. But we have the body camera footage. You're going to hear officers sort of yucking it up with each other after this arrest happened. So not good there. Not good at all. Then we're going to talk about Ghislaine Maxwell. Been a little while since we've revisited this case. She had court very recently. She had an arraignment where she was sort of having to answer for new charges. As you recall, there was another victim and additional charges added on to her already old charges, but she already had about 3 different victims. They just added a 4th one, so she had an arraignment, and then we know that the Second Circuit Court of Appeals said that she's not getting out of custody. If you recall here, there's sort of been this cat and mouse game going on where the courts keep trying to make sure that she can't get out of custody, and she keeps trying to submit a new motion for renewed bail requests, and the Court of Appeals came down today and said, no, not going to happen. You're not going anywhere. So we've got a lot to get into, a lot of stories there, and we want to make sure that you are a part of the program so that you can ask questions, leave comments, lob criticisms, whatever you want to do. You can do that on this channel. It's kind of a nice thing. So you can participate by going over to watchingthewatchers.locals.com in a web browser. That's our community where you can actually ask questions. You can go on there. You'll see a live chat that Miss Faith is monitoring right now. So any good questions, she's going to clip those and throw them right in my slide. So if you want to be a part of the show, that's the place to do that. You can also download a free copy of my book. It's called Beginning to Winning. It's available there. You can get a discount code for my Existence System course, which is back and functional today. So we fixed that little hiccup that we had yesterday. That's available over at robertgruler.com. If you want to support the show, you can buy that course. It's kind of a fun course. Hopefully you get some value out of it. So go check that out if you are interested. All right, and so let's get into the news of the day. Capitol Hill Riot. It's been some time since we've checked back in on those cases. We've got 2 big ones today that we want to check in on. We've got Julian Khater and George Tanios. These are 2 gentlemen who were part of the Capitol Hill riots. And they had court today, so they were in front of a judge today trying to get out of custody, really. If you recall, this happened back on January 6th, and they have been sitting in custody ever since. Many other people in this country get out of custody on bail, especially if they are not criminals, right? If they don't have a criminal history, if they haven't done anything that is particularly heinous, people get out on bail all the time. We've talked about this. Kyle Rittenhouse out on bail. We've talked about Derek Chauvin out on bail. Kim Potter, the officer who shot and killed Dante Wright, she's out on bail. And the list goes on and on and on. People get out of custody all the time. So the question here has been, why are these defendants in custody for something that's pretty minor, sort of as a protest, a riot? They're still being housed in federal custody. And so there was court today. We're going to check back in. Adam Classfield over from lawandcrime.com did a live thread on the proceedings. So he called into court and was listening to everything. So we're going to check in with him, and we're going to go over to Law and Crime, and they're going to walk us through what happened in court. You can see here, these are the two people that we're talking about. So this is one person who's inside the building, inside the congressional building. And then this is another sort of red box that was placed around. This is part of the government's discovery, part of their evidence, saying that there was some bear spray, obviously, that was being sort of, sprayed around right then and there. So Classfield says the late Capitol Police Officer Brian Sicknick's accused assailants, George Tanios and Julian Khater, are renewing their pretrial release requests. They filed their motions the day after the D.C. medical examiner's ruling on Sicknick. And so he went through the thread. And so you recall that we learned back on right about April 18th, that Officer Sicknick, many people were saying that he was killed by the MAGA, riots. They were saying that there was a fire extinguisher. Remember that the mainstream media was reporting this. It was so prevalent of a hoax narrative that was being spread all around this country that it even made it into the Democrats' impeachment memorandum that was used in the second impeachment of Donald Trump. So this was sort of the great big lie that was being spread around, that Officer Sicknick was killed by fire extinguisher as a result of the riots. Obviously, that didn't happen. We knew that didn't happen because they were trying to hide the results for a very long time. Well, we know back in sort of mid-April that they finally came to that acknowledgement. They kind of finally released that, hey, he died of natural causes. And we talked about it on this show, that even the Capitol Police, they are sort of in denial about it. Remember, they posted this. The medical examiner finds that the U.S. Capitol Police Officer Brian Sicknick died of natural causes. This was part of their press release that they sent back on April 19th. It says the U.S. Capitol Police accepts the findings from the D.C. medical examiner that Brian Sicknick died of natural causes. So it's good they accept it. Then they go on to say, this does not change the fact that he died in the line of duty, courageously defending Congress and the Capitol, which is obviously not, it's just not accurate, right? He died of natural causes. He didn't die in the line of duty. That would have been killed in action, not dying of natural causes. But whatever, they're mourning the loss of somebody that they care about. So we'll give them that benefit on that one. Now, they are saying that Khater and Tanios, you recall this came back on April 19th, they're saying they're each charged with one count of conspiracy to injure an officer, 3 counts of assault on a federal officer with a dangerous weapon, 1 count of civil disorder, obstruction, and physical violence, all on Capitol grounds, blah, 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 right? A whole slew of charges. Now, you can see that a good portion of those directly relate to Officer Sicknick, and the allegation here was largely that they were using bear spray to sort of assault the officer. So we're going to go through the story here over from Law and Crime. As I mentioned, it says here they do not mention their autopsy report in their motion. So the way this works, just to frame this out a little bit, right? We've talked about this a lot on this channel, really ever since a lot of these defendants who were a part of the Capitol Hill riots, ever since they all got rounded up, the FBI is still working on it, that we want to make sure that these individuals, really anybody in this country that is on the receiving end of a dog pile, legally needs to be defended. If there's, if the entire country is sort of aligned to make sure that a particular segment of the country gets penalized, that's when, sort of defense attorneys, our ears perk up. At least mine do. Not all defense attorneys do. But it's saying, hey, there's somebody here who needs your help. It's sort of like the bat signal, right? Fly in there and make sure that they're not getting railroaded, because the first thing that goes anytime that there is sort of an emotional prosecution are things like the presumption of innocence and due process. Both incredibly important. We've got, a nation of laws here for a reason. And so when you start to see what happened as a result of the Capitol Hill riots, the entire infrastructure sort of organized against these defendants, which is not a good thing. Politically, the media, of course, was dogpiling on them. Congress people were, everybody was, they still are, and they actually made it the subject of the impeachment of the president, which in my opinion was really kind of the impeachment of the Republican Party, or at least the Trump version of the Republican Party. It was a symbolic sort of attempt to cut the head off of the snake and watch the rest of the body wither away and die. I'm not sure how effective it was. Arguably, maybe it was, but we'll see. But the point here is the Capitol Hill rioters, the Capitol Hill protesters, they deserve the same due process, the same presumption of innocence as the rest of us. And so when they were being held in custody, myself and others have been scratching our heads going, what the heck is happening here? This is not fair, because other people in other parts of the country are being let out of custody on bail. They're being granted release, even though some of their crimes are more heinous than any of the allegations that took place for the January 6th defendants. And I've got some examples of it later on, but let's go through this. Right now, they are trying to get back out of custody. There was a new report that was released saying that Officer Sicknick did in fact die of natural causes. There was nothing to do with bear spray or a fire extinguisher or anything else. It was just natural causes. So they wanted to renew their motion. They wanted to re-request an attempt to get out of custody, given the fact that the medical examiner themselves are confirming it was natural causes. So let's go through the story. It says the day after DC medical examiner's office released a ruling finding that Sicknick died of natural causes, the officers accused assailants filed separate motions for pretrial release. Neither of them mentioned the news of the autopsy or the finding that he died from stroke. So the motions by two attorneys, George Tanios and Julian Khater, running a combined 48 pages, do not even mention Officer Sicknick's name. Quote, it's hard to not think of the events that unfolded on January 6th and not have a visceral reaction, particularly as rioters entered the Capitol building by breaking windows and ramming open doors, says Khater's lawyer Joseph Tacopina in his 28-page brief that was filed today. Julian Khater was not one of them. He never entered the Capitol building, never sought to threaten members of Congress, never intended to forcibly interfere with the peaceful transition of power. Instead, the act attributed to him was a limited and isolated one that never transgressed the barrier that lay directly before him. The alleged act was spraying a canister of bear spray at Sicknick and two other officers. Prosecutors never alleged Sicknick's assault caused his death. And no, they didn't, but everybody else did. Media did, Democrats did, Congress people did, senators did. And the list goes on and on. So apparently, at least for Khater, he was never even in the building, according to his attorney. Khater does not appear to deny the assault outright in his motion for bond, which does question whether the government has evidence connecting him to the crime. So here's what else they say in there. Specifically, as detailed in the criminal complaint, Mr. Khater is accused of appearing to hold such a canister while spraying it in one continuous sweeping motion of his arm from side to side and, quote, in the direction of law enforcement officers, while standing as much as 8 feet away from them after emphatically yelling out, quote, they just sprayed me. The defense motion states, right? And so they're going to paint this picture of madness, of chaos, which is exactly the right move, because not only was that accurate, right? We saw all of the videos, we talked about it. We were on the show right after it happened, and it was madness. There was a lot of people spraying, a lot of things, a lot of different directions, a lot of smoke, a lot of pepper spray, a lot of everything, right? And some people were, you saw that in a lot of videos. People were just sort of, washing their faces off and spitting and things like that because it was everywhere. So who knows whether it was these guys or somebody else. I mean, even the officers were spraying pepper spray all over the place. So it's kind of madness, and that is a good thing to really magnify if you are a defendant. If you're a defense attorney, of course you're going to say, no, I mean, there was pepper spray all over the place, bear spray all over the place. It wasn't my client. It could have been him or him or him or him or any one of the other 50 people that were on the camera that we just watched, on the video we just watched. Khater's lawyers note that the reference to their client, quote, appearing to hold the canister is less than definitive, and took aim at the officers is at best equivocal or doubtful, as you might say. According to charging papers, Khater told Tanios, give me that bear spray, an apparent reference to the bear spray. He says, actually, give me that bear S, right? The S word there. Going further, then accused co-conspirator in his defense, Tanios denies assaulting any officers with any chemicals. according to his defense attorney, who's with the Federal Public Defender's Office. She says Mr. Tanios denies conspiring to injure officers, denies aiding and abetting any other officers in any crimes, denies assaulting any officer with a dangerous weapon, denies any physical violence on restricted grounds while carrying a dangerous weapon, denies causing bodily injury. Mr. Tanios asserts his innocence, and given his non-violent and non-criminal history, he does not pose a danger to the community or any other person. So, that's a public defender. Federal public defender is very good, in my experience. People who know what they're doing, they do a lot of it. I don't, obviously know Elizabeth Gross, but somebody who, sounds like it's very nuts and bolts, nothing flashy, right? The other attorney was making some arguments. She just said, no, we're we're not giving an inch here. Deny, 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 deny. We deny all of that. We maintain our presumption of innocence, and we demand due process and release him. We'll see what the judge does. Tanios' lawyers claims the government has slim evidence to the contrary. Other than Mr. Tanios being present, the video clips fail to show much at all in terms of the criminal acts allegedly committed by him, said his attorney. The video clips failed to show any intent to harm officers, knowledge that officers would be injured, or any agreement by Mr. Tanios to do harm. Video clips failed to show that he used any weapon, chemical spray, or inflammatory agent. Furthermore, the video clips failed to show Tanios provided Khater with any item that could be used to injure the officers at the Capitol. This is a far cry from strong evidence, and it is the only evidence the government relied upon, right? So it's terrible evidence. It's not any good. And it's their burden. So this attorney's, just like I said, very nuts and bolts, making sure that it's their burden. They've got the burden to produce the evidence, the burden of production, and the burden of presentation, right? The burden of proof is what they have to meet. And, this is something that's not uncommon. This happens regularly. Think about the Old Town or the 6th Street or the Avenue, whatever that avenue is in your city, or whatever street that is in your city that everybody goes to and gets rowdy, right? If there's a big madness, if there's a big event, a lot of people are engaged in fights. Happens all the time here in Scottsdale, right down the street, right? The police sort of are on bicycles. They're just rounding everybody up, taking them downtown, throwing them in the jails, letting the courts and the lawyers and the prosecutors sort everything out the next day. Oftentimes, it's the evidence is bad because they don't really have much of anything. And so when you start to piece it all together, you recognize that this person just kind of got caught up in something that maybe they shouldn't have been there. Maybe they weren't the most innocent person there, but the evidence is not enough to convict them of a crime. But the police just round everybody up, throw them into the back of a squad car, drive them all down to the station, and figure they can deal with it the next day. The problem is that person now has to hire a lawyer. They've already had their liberty deprived for that night. They have pending criminal charges. They've got the stain of criminality on them that's going to exist in public records and court documents and mugshot websites and everything all over the place. And somehow, that's not an infraction on any of their freedom, and there's no compensation or anything that they can be compensated for as a result of that deprivation. But I digress. That's a whole separate topic. What the heck am I even talking about? Let's get back to the Capitol Hill people. Though neither of the briefs mention Sicknick, both mention the D.C. Circuit ruling that has been proved to be a boon for numerous Capitol riot suspects. The case of the so-called zip tie guy, Eric Munchell, who was spotted traipsing around the Senate carrying tactical restraints. In a ruling that ultimately led to pretrial release for Munchell, the zip tie guy, and his mother, the D.C. Circuit raised the bar for the government to keep other members of the Trump mob locked up until juries hear their cases. Khater noted that multiple members of the extremist Proud Boy groups have benefited from that precedent, as has Hunter Emeke, charged with breaking a window of the building, and Mark Leffingwell, who allegedly struck an officer as authorities tried to stop a group that had broken into the Capitol. So there was a Court of Appeals ruling that came back down and said, basically, you guys are being ridiculous here. A lot of people in this country get charged with crimes. A lot of them are more heinous than breaking a window or trespassing onto government property, which is essentially what this was. This was a government building, a very important government building, one with a lot of importance and a lot of sacredness. And I agree with everybody that what we saw there was reprehensible and grotesque, and I've never endorsed it or been somebody who supports it or tries to make excuses for it. But at the same time, we want to make sure that the people who are being charged with crimes here, who are on the receiving end of the dog pile, or at the very bottom of the pack, that they get the same rights and privileges that all of us are afforded. We have to demand that they get it, Otherwise, if we just take certain contingents of our society and say, oh, those people don't deserve rights because what they did was really bad. Oh, Derek Chauvin doesn't deserve the presumption of innocence because we saw the video. We don't need actually a trial. Why do we even need to do this stuff? That is when these principles and concepts have to be fought for even harder in these certain circumstances. So that is law and crime. We also have Zoe Tillman, who gave us some good insight as to what was happening today. Said, hello from Judge Hogan's virtual courtroom, where arguments are set to begin shortly on release motions filed by the two who have been charged, Julian Khater and George Tanios. And she gave us a clip from the preliminary statement here. Says, this is a little bit of the clip that we were reading about from Khater's preliminary motion. At the outset, the defense recognizes the surrounding circumstances. In this case, they evoke emotion. But we saw here, Julian Khater was not one of them, never entered the building. The act attributed to him was limited and isolated. According to the detailed criminal complaint that was filed in docket number, that singular act of using a bear spray canister, which he personally did not purchase or carry to the Capitol, occurred as much as 8 feet away from officers, only after he emphatically yelled out that he himself was just sprayed. Excuse me. So he is sort of, I guess maybe detailing the if you punch me, I punch you back motif, which is not really a good defense, but it's understandable, right? He got sprayed, so they're just trying to provide some context. Clearly, the circumstances giving rise to this case are extraordinarily unique. In accordance with the fact below as discussed, many defendants charged with violent or aggressive behavior have been released pending trial. These factors, coupled with the upstanding history and characteristics of Mr. Khater, who has absolutely no prior contact with the criminal justice system, support his pre-trial release. In fact, any notion that he poses a risk of flight or a danger to the community is undercut by the 12.5 letters attached to his submission. In those letters, people who know Mr. Khater best extol his exemplary background and character. Accordingly, for the reasons set forth and detailed below, the defense requested he be released, and they put together this bail package with stringent pretrial conditions. And listen to this. Listen to what they're offering. This is massive. $15 million bond package secured by 5 properties comprising approximately $1.5 million in equity, guaranteed by 16 family members who will co-sign as financially responsible sureties. Home detention with electronic monitoring and a condition that Mr. Khater surrender any and all passports in his possession. For an assault case, essentially, is what it is. A trespass and an assault case, which is arguable, right? The evidence here is shoddy at best, as we have seen. It's bear spray in a canister with some imagery from Madness. We now know Officer Sicknick didn't die from that. It was natural causes, had nothing to do with it. And allegedly, he was the officer involved in any of this stuff. So the assault charges could stick even without proof of causation of death. Obviously, if their assault with the bear spray had led to Officer Sicknick's death, then they would be charged with more serious crimes, but that didn't happen. And there's not even any indication from what we know that the bear spray landed on Sicknick to the extent that the bear spray impacted Sicknick, right? Might have physically hit his body, but we don't know, as far as I know, whether there was a medical report or examination that said anything from the bear spray was consequential in his death. It wasn't contributing to it at all. So would it have been an assault if there's no sort of physical evidence that it actually landed on him, right? There's people spraying stuff all over the place. Was it these guys' bear spray or somebody else's bear spray, or was it the officer's bear spray? Because they were also spraying from multiple different directions. We've watched a lot of the videos here, as I'm sure you have. So the question here, why is he still in custody? He's got no criminal record at all. Not a flight risk from what we can see here. We've got the family now posting up $15 million in bond for a trespass case, essentially, is what this is. 16 family members are going to co-sign. They're going to put up 5 of their properties as collateral, $1.5 million in equity, to get him out of custody. And these judges are going, gosh, I don't know. These people are a threat to our democracy. They're dangerous. They're dangerous to society, and they're a flight risk. They're not. It's not accurate. This is more than reasonable. If this guy does not get out of custody, oh my goodness, that is a travesty of justice. I think that he will now that we have a DC Circuit Court ruling. We have a very generous bond. We have precedent now that other defendants are being released, but my gosh, it's April. It's going to be May by the time the time this guy gets out of custody. Many other people around the country have in fact been released. I want to share an article that I found over from American Greatness. This is sort of a summation of why Sicknick's narrative failed. Says the Fed's non-existent case against the alleged Sicknick assailants. The cause of the Capitol Police Officer Brian Sicknick's untimely death on January 6th is finally settled, but the prosecution of his alleged attackers rages on. After months of dishonest accounts about what happened to Sicknick, first that he was bludgeoned to death by the insurrectionists with a fire extinguisher, and then that he died of an allergic reaction to bear spray, the D.C. Medical Examiner's Office confirmed that he died of stroke. The chemical sprayed in his direction during the chaos outside the Capitol on January 6th did not contribute to his death, according to this reporter. The article continues. In its haste to bolster the new narrative maintaining Sicknick was killed by rioters wielding bear spray, the acting attorney general was in on the lie from the start. Justice Department charged 2 men with the attack. We just talked about him. George Tanios, Julian Khater were arrested March 14th and charged with several crimes, including 4 counts related to possession of a deadly or use of a dangerous weapon, which is the bear spray, allegedly. They've been behind bars ever since. Ever since. Both were transported to the nation's capital, where they joined dozens of January 6 detainees. They were held in solitary confinement in D.C. jail. A judge on Tuesday will consider motions filed by their attorneys, which was today, to release both defendants. They deny all charges. As this reporter has reported in the past, federal courts at the direction of Joe Biden's Justice Department are denying bond to nonviolent protesters as their cases continue to slow slog through an intentionally overloaded D.C. judicial system. Another thing that I've screamed about. This reporter is Julie Kelly over at amgreatness.com. So go check her out. And so, this is something I've been saying, that the government prosecutors in this case have filed motions saying, we're overloaded. We're too busy. So we need continuances. They asked for 60-day continuances, which, look, wouldn't be that bad if people were out of custody. You sort of get one or the other. You don't get more time on your case at the same time that you're demanding that nobody gets out of custody. Well, because they're opposing interests. The people want to get out of custody. They want a resolution on their case quickly so that they can get back to living their lives. They're being penalized because the government can't get their act together because they're so overloaded. They need 60-day continuances. Their systems are overloaded in DC, even though, it's the center of our government, right? They should have more resources than any other jurisdiction in this entire country. And for some reason they don't. They can't even process something like another 300 additional cases that are working their way as a result of the January 6th stuff. So anyways, they're denying bond. The presumption of innocence has been suspended for Trump supporters involved in the January 6th protests, largely based on supposed thought crime of doubting the legitimacy of the election. Before announcing his ruling, a federal magistrate berated Tanios from the bench. Everyone in our country knows what happened on January 6th, said Judge Michael Alloy during a March 22nd hearing. Says, we also generally know that they were supporting the president who would not accept that he was defeated in an election. So we have created this culture radicalized by hate and just refusal to really accept the result of a democratic process. Don't you love when judges just scold you like a child from the bench? Oh my gosh. Alloy also suggested the bear spray killed Sicknick. It was surreal, the judge said. Okay, so that was inaccurate, right? Surreal to see a video of an officer who's no longer with us and describe what happened as an assault on our nation's home. Very dramatic. Law enforcement officials have argued in court pleadings the defendants shouldn't have unfettered access to tens of thousands of hours of video evidence because they might pass along the information to those who wish to attack the Capitol again. You see this? Law enforcement is arguing that we're going to keep you in custody, not let you out. We're going to no bond, no bail. Okay, even though you have the presumption of innocence, even though our system says that technically you're innocent right now, and that our laws heavily favor people getting out of custody because of that fact, right? If you're presumed innocent, then why are we penalizing you by ripping you away from your livelihood unless the threshold is extremely high, unless you're going to leave the country and not come back to court, and there's nothing we can do to ensure that you come back, or you are a danger to the community and there's nothing we can do to prevent that from happening, then we'll keep you in custody. But that standard hasn't been met here. And they want to keep you in there. Then, when they're not letting you out, they need a continuance. They need another 60 days in order to work their cases up. So while you're rotting away in custody, they need more time to do their work. All right. Then, when you want to defend yourself, they're arguing in court pleadings, oh no, you shouldn't have unfettered access to any of this stuff. No unfettered access, because you might want to attack the Capitol again. Instead, according to a recent Political article, prosecutors are, quote, working to build an archive of video that would permit defendants to peruse relevant clips, but sharply restrict their access and permit prosecutors a chance to object if they feel any such footage could be misused or present a risk. This appears to be the situation for Tanios and Khater. An attorney for Tanios accused the government of presenting only tiny, limited seconds of evidence and refusing to allow the defense team an opportunity to see the rest. We see limited interpretation of videos and their view of those videos because they are tiny little pieces of them handpicked by the government to show the court. The sketchy photographic evidence against Tanios and Khater included in charging documents isn't the government's only problem. Law enforcement doesn't know for certain if they use pepper spray at all. Under questioning by Tanios' lawyer last month, FBI Special Agent Riley Palmertree could not confirm that either man pulled the trigger on the bear spray can. Here's what the attorney said. Did Khater use the bear spray that day? The FBI agent says, not that I know of, but that's for further investigation. The investigation is still going on regarding the bear sprays. Attorney says, okay, so it's your understanding that Khater used a small canister of OC spray with the black handle that was sort of like on a keychain, or could be a keychain. FBI agent says, that's according to my investigation, which is still going on. The attorney says, you don't have any reason to believe that the bear spray was deployed that day at all, do you? Agent says, I have the bear spray cans myself, and I haven't submitted them for analysis, so that's what I would need to do. It's a very serious thing, and I have to be sure in a scientific way the best that I can. So no evidence that they even used it. So are you keeping count now? You're just rolling it up. What a travesty of justice this is. I don't care what side of the political aisle you are on. This is a joke. This is holding people in custody absent good cause. This is asking for continuance absent good cause. And this is doing so without evidence that is justifiable, in my opinion. You have the FBI agent himself saying, well, we don't even know if he used the bear spray. Well, do you have any other evidence of an assault, or what is the deadly weapon? Because I didn't see any guns there. If it's all deadly weapons charges, they didn't use the bear spray. Is that still a deadly weapon? And then when you want to defend yourself, you don't even get any evidence. Isn't that nice? It's our government. Here we've got, in a separate filing, Julian Khater's lawyers argued their client and Tanios were sprayed by others in the crowd, perhaps police officers, and never even used the bear spray. The government even admitted in its affidavit that Khater at one point yelled out, "They just sprayed me." Therefore, it's a strong possibility the officers, including Sicknick, who reportedly told the family members he was hit by pepper spray during the protest, were sprayed by something other than the bear repellent. Khater's family is asking the court to release him on a $15 million bond guaranteed by 16 family members, as one journalist noted. Judge Thomas Hogan will hear the case on Tuesday and then decide whether to keep Khater and Tanios behind bars until their next court date, which is going to be in May, so that's coming up. There's no reason to keep these men in jail, Julie Kelly says, let alone in solitary confinement. Cherry-picked video evidence does not support the weapons charges against them. The chief investigator confessed no evidence exists to prove the can of bear spray was ever used or that Khater or anyone sprayed it, including the police officers. Justice Department's refusal to allow access to video evidence raises plenty of red flags. Neither man has a criminal record. Tanios and Khater pose no threat to society. Their only crime, as is the case with hundreds of nonviolent Capitol protesters, was supporting Donald Trump and daring to question the validity of the 2020 presidential elections, a doubt shared by tens of millions of Americans, but nobody on YouTube, of course, and yours truly also, right? We love Joe Biden over here. All right, so let's take a look at some questions and see what people over at our community on watchingthewatchers.locals.com have to say. And for some reason, my slides aren't syncing, so I am now having to open our backup solution, which is happening right now. So give me one quick second. And it looks like we've got this queued up. We have our first question over from Gregory Nichols. Says, Robert, I've been focusing on a project the past couple of days. I'm in Florida, End of night, two white women are having a debate discussion over Chauvin. Views followed along skin color. But what was shocking to me was when the black lady became vehement. When one white lady said that Floyd was in the car, the black lady said he was never in the car. Read the transcripts. That video isn't what's real. So that's an interesting observation that you have there, Gregory. You know, I think that there are, of course, going to be racial components in any conversation surrounding Chauvin. I do notice, I remember that AG Ellison, who was, of course, the AG who was managing that case out of Minnesota, actually came out and said that he felt bad for Chauvin very recently and that he didn't think it had anything to do with race. And, you know, I'm not real sure that I disagree with him. I made that point about this a lot on this channel, right? Every time there's police brutality or police interactions that are taking place in this country, everybody wants to jump onto this, you know, this narrative that it's all about racism. And I've said this many times on this show. I've seen black cops beat the heck out of black people. I've seen white cops beat the heck out of white people. I've seen Hispanic cops beat the heck out of Hispanic people. I've seen white cops beat black people and black cops beat white people. I've seen it all. I've seen a smorgasbord of police beatings and police brutality and police misconduct that crosses the boundaries of race and demographics. Isn't that a beautiful thing? The police are equal opportunity beaters. They just beat the hell out of everybody. I mean, it happens. I would say, you know, I don't even know what the data says on this, but, you know, disproportionately in certain communities. But when you start running the data, you can get into really dicey water, right? You can say that, yes, there are technically a higher number of white people in this country who are killed by police than there are black people. But then when you sort of, you know, normalize the numbers based on population, then you say, well, actually, you know, as a percent of population, it does look like black people are actually being killed by officers more. But then you start normalizing those numbers based on number of arrests. And you say, okay, well, yes, technically that African Americans are a smaller segment of the country in terms of percentage of demographics, percentage of population, but they are responsible for a higher number of arrests. And so you say, well, of course they're killed more by officers, police, not just white officers, police in general, based on the fact that they're committing more crimes. And then the response to that is, yeah, but it's the police that are being racist and overly penalizing and overly punitive in their demographics, in their neighborhoods. If the police weren't racist, then we wouldn't have this hyper focus on certain communities and certain demographics. And so you can see, you know, how you can sort of just keep this conversation can spiral on and on and on. It's like the song that never ends, right? It just keeps going on and on, my friends. And we all have to have that stuck in our head now because I just brought it up. So let's see what else we've got. Liberty or Death says, this is amazing. If these people were able to have their right to a speedy trial, they would be out of jail if had been convicted. What exactly right? Yeah. He says, what is the penalty for trespass in Arizona? I'm not sure about DC, but in Texas, it's a misdemeanor, max of a few grand and 6 months. Yeah. So Liberty's exactly right. I mean, for most trespass cases, it's diversion. It's you go take a class. So let's say, for example, that you're at a baseball game. They ask you to leave. You don't leave. You get thrown out. Trespass, right? Cause a commotion, disorderly conduct, all of those things. Probably going to take an alcohol class or an adult responsibility class and have your criminal charges dismissed. Now, let's say you did something that was more serious, right? Like you trespassed into a government building and you broke a window and you're very mad about it. In Arizona, it's still a misdemeanor. It's still a class 1 misdemeanor, unless they wanted to tack on some felony charges and maybe say that the damage you caused reached a certain threshold, monetarily speaking, that it justifies a felony charge, or it is a, you know, there's some aggravating factor that would take it out of misdemeanor status. But even then, a misdemeanor status is 6 months max. And almost nobody gets that for misdemeanors, especially if you've got no criminal record, no priors, nothing like that. It's a slap on the wrist. And here, right, if these guys have been in custody since, let's say, mid-January, they've been in there. They've done 3 months of time at least. And they probably would have done less than that had they gone to trial and lost and a judge sentenced them. Would they get 6 months? I doubt it. So those are great questions. Thank you so much for sending those over to us over at watchingthewatchers.locals.com. If you want to support the show, that's the place to do it, and we really appreciate it. You can download a free copy of my book. It's called Beginning to Winning, also available on Amazon. You can download a copy of the slides that we just went through, and you can get a new coupon for my Existence Systems course, which is available at robertgruler.com. I'd invite you to go check that out. We really appreciate all your support. All right, so let's change gears a little bit. we've got to talk about another police incident. New information has been released that in 2020, there was a 73-year-old woman by the name of Garner who was arrested. And apparently this woman, we're going to learn more about her, has some mental disorders, some dementia, and some other mental disabilities. And when police came upon her, they took her to the ground. You're going to see as we go through the body camera footage in this segment that they were rough with her. After she was arrested and brought into custody, then the officers reviewed the body camera footage and they were fist bumping each other. They were laughing at each other. They were pointing out that her shoulder popped when they sort of dislocated it. So these officers are yucking it up behind the scenes in their office. And this just leaked out, or this was released. It wasn't even leaked. This was released by Miss Garner's attorneys, who have now filed, of course, a lawsuit seeking monetary damages and compensation for the insanity that these officers put her through. So let's go through this story. We do have some body camera footage in here, so a little bit of a content warning if that is upsetting to you, but nobody dies in this. There's no blood. It is, man being inhumane to other man, man's inhumanity to man, but we are going to go through it. So just a little bit of a heads up if some of that stuff is concerning. So let's take a quick look. Over here, we have new information, as I mentioned, was released. Officer Austin Hop is the name. He comes from Loveland Police Department. He's the person who arrested 73-year-old Garner. This happened in 2020, and he can be seen laughing with other officers in newly released footage as he reviews body camera video from her arrest. This arrest prompted a civil rights lawsuit against Loveland Police Department, which is in Colorado, and several of its employees. Garner's attorneys released the footage along with new information on Garner's detention at the Loveland police station immediately after her arrest. With the new information also came an amended complaint, which adds Officer Tyler Blackett and Sergeant Antelina Hill to the lawsuit. So we've got some bad popo here. We've got Austin Hupp, we've got Tyler Blackett, and Sergeant Antelina Hill, at least suspected to be bad popo. We don't know yet. Loveland police officials have declined to comment on the incident, of course, and new information as the investigation into the arrest proceeds, saying they trust, quote, let's listen to this, they trust the due process. So that's nice. So they trust due process when they're being investigated. But if you're a 73-year-old woman, they just kind of pop your shoulder right out of your socket, throw you in jail, and then go back and laugh about it in their police department. Got it. According to a press release from Sarah Shelke, the attorney representing Garner, in her lawsuit against the police, several officers over her arrest. This happened back on June 26, 2020. Several officers can be seen laughing while reviewing the body camera video. Garner's family hired a sound engineer to enhance the audio in the booking area videos. Okay, so most of this, you can't even hear it ordinarily because these guys are quiet, right? They're not saying, hey, look, we just arrested a 73-year-old, whatever, and kind of under the radar. Hey, check, did you see that? Can you believe that happened? Fist bump, right? Here it is. Let's take a quick listen in. This is them fist bumping. We're going to get to the clip here in a second. You can see these two officers here booking photograph from within the jail. We're going to piece all this together here in a minute, but you can see here a little bit of a love tap. Hey, that's fun. How exciting was that? We're police officers. God, it irritates me. According to the release, city officials have yet to send any apology to the Garner or her family. After the lawsuit was filed, Hop was placed on administrative leave. Assisting Officer Jalali and Supervising Sergeant Phil Metzler were moved to administrative duties. 2 days after the lawsuit and video from the arrest went public, Police Chief Bob Tyser spoke publicly about Garner's arrest, saying he wanted the investigation into the incident to be as transparent as possible. In newly released surveillance video footage that Shelke, the attorney, posted to the Life and Liberty Law Office YouTube page, which I linked down in the description below. So make sure you go give them a check and a nice sub and a nice follow because they deserve it. Hop can be seen laughing with other LPD officers when watching his body camera footage from the arrest of the 80-pound, 5-foot-tall woman who reportedly suffers from dementia. He can be seen early on fist bumping Jalali over the arrest. And we saw that right here, right? So that's Hop here, and that's Jalali over there. The 14-minute compilation video, full video is linked below, includes video footage of the booking area where LPD officers worked and where Garner was being held. The full-on hour-long surveillance video is also on their channel. Early in the video, Blackett can be heard asking Hop if Hop read Garner her Miranda rights when arresting her. Nope, he responds, I did not. Later in the release footage, officers are seen watching Hop's body camera, laughing. As Hop watches, he can be heard laughing, and he celebrates with Jalali and Blackett. In the video, Jalali can be heard saying that body cams are my favorite thing to watch. Just minutes later, she can be seen pulling her hat down over her face, saying, I hate this. This is great, Hop responds. Ready for the pop? Hear the pop? Hop can be heard saying about the apparent dislocation of Garner's shoulder. According to the release, Garner was handcuffed to the bench just 10 feet away from them at the time. Okay, one more time. It says, ready for the pop? Hear the pop? From a police officer with another police officer fist bumping each other. Pop, pop, hear the pop? Horrific statement comes to light after Garner's family hired a sound engineer to enhance the audio on Loveland Police Station booking videos from the day of her arrest. The release said, it's not only a grotesque revelation to come from these booking station videos. According to the release, during the first hour Garner was in custody, she could be heard saying that they hurt my shoulders 22 times. They hurt my wrists 13 times. They kept hurting 8 times, and it hurts 8 times. Garner was allegedly not giving any medical treatment while at the Loveland Police Station. The release also included several new allegations against the department and its members. It says that a blue team report was filed for Garner's arrest, a system that alerts the department to create an official record whenever force is used. Tyser, who I think is the police chief, said, all right, they're going to use the system, information about industry. Great, got all that. Tyser said department officials did not learn about the injuries until the lawsuit was filed. Okay, that's great. Until information was posted online. Okay, so, all right, maybe that's true. Maybe the attorneys didn't send anything over there. I can't imagine they did. You know, typically the way that these things work is you file what's called a notice of claim with the city. So I'm not sure if he's talking about that or he's talking about the direct lawsuit. Who knows? Well, regardless, Blue Team has it, according to the booking area photos. The new release also alleges that Metzler, the supervisor on the scene when Garner was arrested, knew she was injured and authorized that she be kept in a cell without medical evaluation or treatment, even coming through to check on the status of the report writing and knowing Garner was still locked away and injured just mere feet away. Hill, another supervising officer who had been added to the complaint, allegedly came through the booking area while Garner was being held and personally reviewed Hop's affidavit describing his use of force, allegedly notarized it, laughed, and then, quote, joined in on the jokes that were being made regarding Miss Garner's age and small size, her injuries, and the fact that the hog tie used on her got her blood on it and so would need to be washed, according to the press release. On a 73-year-old woman, right? This is grandma that has dementia. Cops bust her shoulder, pop it out of the socket, hog tie her. She's bleeding on herself. Take her back to the station, throw her in the cell, know that she's injured, laugh about it, fist bump each other, check on her report. Hey, is a report being written? And then laughing about it with each other. As she's in pain, in the other room, crying. Neck, back, wrists, everything. I'm 73. You guys just beat the hell out of me. Let's take a look at what happened. Here's the body camera.
Wait!
Play it this way. Ma'am, police, stop. You want to stop with lights on, siren? Stop. You just left Walmart. Do you need to be arrested right now? No. Okay. Let's stop. Come on.
I'm going home.
No, on the ground. Stay on the ground. On the ground.
Yeah, so you watch that, it kind of makes your heart sink a little bit. Still makes mine sink because that's a 73-year-old woman with dementia who's 80 pounds. Obvious, right? Not a well person, and they just picked her up, kind of threw her in there like a piece of cattle, which is disgusting and sick. Now, even I, somebody who's seen a lot of this stuff, can watch something like this and go, that makes my stomach churn a little bit because of my compassion, I think, for fellow man. And when I see other people doing stuff like this to other people with almost no sense of humanity and just clearly cold, mechanical, and calculating, it really is grotesque. Now, that being said, this happens all the time in this country. This is not a new thing. This is pretty disturbing because this happened to a 73-year-old woman, but this happens all the time, right? If you're a 26-year-old person in the middle of a mental health crisis, doesn't matter what color you are, this happens across the board. This is white. These are white cops doing this to a white woman. I know people want to make all of these police incidents about race. I don't really think so. I think it's a cultural thing. I think that it's a big problem with law enforcement and how they think they are supposed to act when they're dealing with civilians. These people, I feel like they're operating like they're in the middle of Fallujah, right? Like they're paradropping into, Baghdad or something like that when they're out dealing with a $13 theft from Walmart. They got to rough this woman up and then laugh about it when they go back into the station. Very, very grotesque, unfortunately, all too common. And as we now know, almost zero accountability in the police department, at least if you want to take the facts on the merits. If you want to take the facts that were alleged in the lawsuit on the face value, they're saying, well, nobody even knew about it, right? We had this woman who was injured. Several people sign off on the use of force document. Chief of police now comes out and says, well, I want to be transparent about it. But apparently they didn't even know about it until the lawsuit was filed. So now we're talking about checks and balances and internal procedures. When there has been a use of force, what are the police doing in order to vet what happened, make sure that nothing happened that was problematic? Until the defense sues, until somebody sues about this. Now all of these cops are going to just, what are they going to do? They're going to respond. They're going to say, no, qualified immunity, right? She was arrested. She was lawfully arrested. Everything that they did there, I think, was legally was okay, right? She was apparently a suspect in a shoplifting, $13, resisted arrest technically, right? The cops can go through this and justify everything that they did, but guess what? It was still wrong. And are there going to be repercussions for it? We'll find out. Here is a little bit more video about what happened back in the police station. This is a little note there at the bottom, says, notice this video has been edited. The complete uncut video is over on their channel. Video says they're whispering to each other. Fist bump just happened. How do you think it went?
No, I didn't.
I thought we were taking repercussions.
But every time I would try to jump in, I got pushed off to the side. So I don't want you to think that I'm not acting.
I didn't think you were. I thought you were right in there the whole game. Did I push you up to the top? Very sorry. I didn't think there's
Yeah, it's okay. I just don't want you to think I was not playing.
You were definitely playing. You're a lot of help. She's just very flexible and very... I had her car when we first got there. And I was like, play. I was pushing her. I was like,
That's what you mentioned is.
yeah.
No doubt that's on the car. There's more than just that guy.
I had him all calm down. And like, oh, babe, I get it now. And then she was fighting still. You think she's more than 46? She thinks it.
She told us.
She's 73. Yeah, I'm a little worried that it's like senile stuff.
Yeah, you should be.
Her hands are strong and disconnected from the bench now. She's just very flexible. Stupid question, but I gotta ask you, rear Miranda. All right, I'll meet you guys downstairs. Cool, thanks.
All right. So as you saw, right, kind of yucking it up. Now, it does sound like they're talking about like kind of glory stories, you know, hey, maybe it was her first arrest or their second arrest. You know, I don't know what Loveland looks like. I don't know how much action they get, but apparently this was something that was sort of exciting for them. They were talking about it in that manner. Like, hey, how did you do? How did you do? How did you think I did? Well, I thought you did fine. Well, I don't know. I don't want you to think that I wasn't participating is what the female officer said. She said, well, you know, I didn't want you to think that I was sort of backing away. He said, no, you did great. You know, you helped her. She was a fighter. She was squirmy. She was flexible. Did you hear the pop though? I was like, oh no, you know, kind of like this whole thing was just, you know, commentary. Then he starts to wise up a little bit. You can see him kind of pause when they go, did you see she was born in 46, 73? He goes, oh, it's like my grandma. So yeah, not ideal. A little bit concerned that maybe she's senile. Maybe she's got dementia. Maybe something is going to come of this, obviously. So why is this stuff common parlance? Why do they all act like this? Why do they go back, sit at their desks, write their reports, and yuck it up over this stuff? And I understand, right? I understand, you know, like if you're a waiter or something, right? Oh, it's crazy out there. That customer was a loser, whatever. Customer's a jerk, right? Attorneys do it. Doctors do it. Everybody has sort of that gallows humor to some degree. But this was a 73-year-old woman, and they just broke her shoulder, popped it out of socket. And they're just, what makes humanity evaporate from a person that you can do that to somebody else? How does that work? Over $13 in a Walmart shoplifting situation. It's disgusting. Here's some more. Here's a scene. It says, Sergeant Metzler is the officer's supervisor. He was on scene with them. He knows that Karen is injured. Then Sergeant Metzler is the officer's supervisor. Okay, so what's going on here? Let's see.
A little bloody, a little muddy, that's how it works.
Yeah, is the blood on her? Yeah, that's her blood.
Good. Okay.
Got him?
I have this. Hey, we're gonna sit in the car, okay?
Yeah. All right. So, right, it sounds like these are two kind of high school kids, graduates, just talking about it. Still sort of pumped up by the adrenaline of an arrest. Maybe it was their first arrest. Maybe they're 20-something years old. I don't know. Let's see what else we've got.
Sexual? When you charge him down?
No.
See what happened there? Does she need to be charged with a felony? See how that happens? Just couple cops poking around. Oh, maybe we will charge her with a felony. Maybe that's justified. We've got more clips. We're going to skip through them. Let's take a look at some questions over from watchingthewatchers.locals.com. Gross behavior. Let's see what else we've got, Miss Faith. Do we have some other questions? My PowerPoints are not updating. We're having another technical problem here today, so we're trying to sort through that. Doesn't look like I have any questions queued up on this one. So we'll just, hang on, she's sending me another link. All right, so now it's updated. All right, we've got some questions. Says, first and foremost, we have Nadar Blasier says, this really infuriates me, especially when DC... all right, so not sure what's going on over here. Let's take a look here. First question's up from Joe Snow. Says, Robert, most cops are absolutely disgusting people. Is that a fair assessment? I actually don't think it's fair. I think that most cops are not disgusting people. I think that most cops are good people. Most cops are like the rest of us. Most cops are just like you and I, right? They're sort of living their lives. They want to start families and they want to do some good in the world. And I think that is the vast majority of officers. I think they are part of a culture that has a lot of problems that protect some of the bad officers that are there. And unfortunately, the difference between maybe the police industry and our industry are that they have a total monopoly on power. They have a lot of protections that you or I do not have, right? If you sell a widget and your widget kills somebody, well, you get sued or you go to jail for that and you're out of business. It's over. Police, there's no skin in the game in that regard. They have a contract with the government to do whatever they want, and they have a lot of power when executing those governments, those contracts with our governments, and that results in some very, very strong protections for some of the less favorable aspects of their force. That is the problem. And so what we see, in my opinion, is we see sort of a higher concentration of really bad officers. And when those officers do something bad, it's catastrophic, right? If you are a bad cashier selling hot dogs at a vending machine, well, and you screw that up, it's not the end of the world. If you're a police officer and you do something bad, well, you end up with a city burning down because something happened in a way that society doesn't like. Consequences are very dramatic. And I think that's why law enforcement, the bad ones really stand out. The good ones, not so much. And part of the problem with that, I think, is that a lot of the good officers, they don't necessarily call out some of the other bad ones. So you don't get to see those who stand out often. We have Liberty or Death says, I'm shocked that Ben Crump did not jump to represent Garner. I know, that's weird. I wonder why. I wonder why that is. Crump's on a lot of other cases. Where is he at with Garner? We've got HLB says, how are events like this not immediately handled with swift firing? Like, we can train people who actually want to be there for people. If my granny or grandma had to handle this, I need a prosthetic because my foot would be so far up their ass. I said it because it deserved it. Let's take a look. We got Sherry Quidney in the house says, are these humans? What is wrong with them? Calling them any kind of animal, pig comes to mind, is an insult to the animals. Yeah, I mean, at least animals are, most of them are pretty nice to each other. Next up, we've got Leroy TMD says, why do cops think every interaction needs to get physical and end in an arrest? What's the punishment for stealing $20 worth of crap from Walmart? Community service? Can we just not issue a citation and move along? Reminds me of the Eric Garner death. He was just selling cigarettes illegally on the corner, right? Well, you saw that cop, right? He gave her about 2 seconds to comply. Soon as she didn't comply, boom, it's it, right? Physical right there. He didn't try to go in front of her and say, ma'am, can you even understand what I'm saying right now? I'm trying to communicate with you. I need you to stop. There's an altercation at Walmart. Apparently you left with some money. I'm trying to figure this out. Please don't walk away from me. Oh, you see that she doesn't understand what you're saying? You see that she has like a glaze. She's looking through your body because she doesn't know what's going on because she has dementia. maybe that's okay. Well, we're dealing with somebody who's not mentally well, right? That would have taken 30 seconds. He didn't. He just said, all right, you're walking away from me. You're disobeying my authority. That's a lawful authority. And I'm out here. I need an adrenaline hit. So he got it on the back of a 73-year-old woman. It's that guy for you. We have Leafy Bug in the house, says at that age, there's a good chance this poor woman will never physically recover from those injuries. I don't even want to think about the psychological damage. Yeah, and what if this woman dies, right? What if she does, right? You hear kind of that joke. It's kind of a bad joke, but as soon as an old person breaks their hip, that's kind of the end of the road. Like, that's the end of the line for them, right? They're not going to be walking. They're not going to be mobile. They're going to have a bunch of surgeries. It's all downhill from there. Well, the government just did this to this woman, 73-year-old woman who, in my opinion, never she was not a threat. She was walking away. He gave her about half of a second to comply before he engaged her, and I think that was inappropriate. Hopefully, he pays the repercussions for that. HLB says, so is there no training for handling psychological issues and de-escalation for those scenarios? I know toddlers who could have handled the situation better. Yeah, there is training for that, of course. I mean, they go through a lot of training. They're sort of ready for that adrenaline hit. They want to get out there and mix it up with people. That's why they became officers. Jack Elias says the only thing a cop will not laugh about is our child molesters and cop killers. Everything else is fair game and will always be fair game once an officer pulls the body of a child out of a dumpster. Yeah, not good. Not good. Last question up from Sasha Sisha says, hi, Rob, Miss Faitjoy, and Ma. Hope y'all are doing well. That video was sad. Excessive force for no reason. They seem so heartless, and it makes you think that if this happened to their elderly loved ones, how would they react to it? Very good question. Very good question indeed. And let's take a quick look at, see if we've got any other questions in here. Not looking like we do. Now, Miss Faith is telling me to check something. 1 second over here. So it's not that. It's because I still don't see you, Miss Faith. All right, no problem. We're going to move on to the next segment because we've got to get out of here in about 22 minutes. So let's move on through it. Ghislaine Maxwell, we've spoken a lot about Ghislaine on this channel, and she just got a bad ruling from the Second Circuit Court of Appeals. She's staying in custody. If anybody had any doubts about that, well, now you don't, because she's not going anywhere. We've long speculated that that was not going to happen. Her attorneys are really trying hard to get her out. They've submitted a number of different bail requests. Judges are denying all of them, and they took up one of the more recent denials to the Court of Appeals. Remember, she's being prosecuted out of a federal district court, and so when they originally denied her bail, she tried to go and appeal that so that she could get a different judge to let her out of custody. Well, of course, the judge didn't do that. We're going to go through the story, and I want to give you an update because, remember, Maxwell has also been charged with a new violation. She had her arraignment on that, I think, last week, and the arraignment is very, very basic. It's basically, hey, we've got new charges against you. We need to make sure you know about that. Do you know about it? Yes, we do. All right, well, nothing's going to change. We're not going to let you out of custody, so we're just going to add this charge to the other charges that you've already got, and we're going to see you at the next court date. So that's really all that was about. But there is a new interesting thing that happened. Ghislaine Maxwell was in custody, and she was meeting in person with her attorneys. Well, when she left that meeting with her lawyers, remember, in custody, she walked out with some papers that her attorneys had given her. According to the jail, that's a big no-no. Not allowed to do that. When she took those documents out, the jail confiscated those documents. Uh-oh. Did they just get her legally protected attorney-client privileged information? And if so, what does that mean for her case? Could be a big problem. A lot of letters, a lot of motions, a lot of issues have been flying back and forth over the last few days in the Ghislaine Maxwell case. And we're going to go through it because it's some pretty impressive lawyering. You know, some people are saying that her legal bill for her defense lawyers got to be in the 10, 20, maybe even $30 million range. They are earning it. They're doing a great job, and we want to show you how they are structuring and laying the framework for more appeals and a really solid defense for Ghislaine Maxwell. So let's go through this article over from the NY Post. You can see here, it says a trio of judges from the Federal Appeals Court in Manhattan denied Ghislaine Maxwell's request to be let out on bail while she's awaiting trial for allegedly procuring underage girls for Jeffrey Epstein. Three-panel judge from the Second Circuit Court handed down a one-page ruling on Tuesday. Today, I'm going to show you that here on the next slide, denying the bid and ordering Maxwell's attorneys to raise any issue they might have about her incarceration in a lower district court. So they're saying you can't get out of custody. And remember, one of the reasons that they wanted her to get out of custody is because they said that the conditions in the jail were so bad. She was losing her hair, couldn't sleep, being woken up. You know, it was the sewage was backing up, had no clean sanitation anywhere. So they were saying she has to be out because the conditions are just so unbearable. Well, the Court of Appeals, as we're going to see, said, well, take that up with the lower level court, district court. All we want to know, or all we're ruling on here, is whether we are going to let you out or not. And the answer is not. So Maxwell's attorney, David Marcus, said in an email that he was, quote, heartbroken by the decision. Says, we are considering our options for next steps. Marcus insisted Maxwell can't prepare for trial because she's awakened every 15 minutes in the night by jail guards who shine flashlights in her cell. In the hearing, Assistant U.S. Attorney Laura Pomerantz said the constant checks were routine in the lockup, a claim Marcus disputed. So there's nothing routine about it. The idea that she has an eye mask on is wrong. She either uses a sock or a towel to block out the light on her own. The appeals court said in the order on Tuesday that, well, she could raise those concerns with District Judge Allison Nathan, who is overseeing her case in the Manhattan Federal Court. The panel wrote, to the extent the appellate seeks relief specific to her sleeping conditions, take it up with the district court. Here is the opinion. You can see here, not much to it at all. United States Court of Appeals for the Second Circuit. You can see this was filed today, April 27th, 2021. Ghislaine Maxwell says here, appeals from the order of the district court denying bail upon due consideration. It is hereby ordered that the district court's orders are affirmed and the appellant court's motion for bail or temporary pretrial release is denied. See that right there? During oral argument, Maxwell expressed concern that she was being improperly deprived of sleep. To the extent that they seek specific relief to her sleeping conditions, take it up with the district court. Signed off on by Catherine O'Hagan Wolf, clerk of the court, signed off on, of course, by the Second Circuit. And so, I don't think this was a big surprise to anybody, right? I've been sort of saying here that I think it's legally unequal that Ghislaine Maxwell is not being left out of custody. There are a lot of other individuals who have committed more heinous crimes than Ghislaine Maxwell who are out on bail, right? For example, you can pick Derek Chauvin, right? He murdered somebody legally now, according to the court of law. He's been convicted of that, and he was out on bail for months. Rittenhouse, same thing. And a lot of the others that we've talked about, right? You can actually kill somebody and be out on bail. But what's different about Ghislaine Maxwell's case is the flight risk component. She had dual citizenship, I think, in France and even maybe in Britain. And many people are saying that she's got unlimited assets, right? She sort of disclosed a lot of this stuff to federal authorities, but is that accurate? If she is out, are we ever going to see her again? Probably not. So I think it is, in fact, the right move that the court is not letting her out. Legally, it may be it's one of those margin cases where most people in her situation, they're going to let him out. She's not most people. She was the number 2 to Jeffrey Epstein. Epstein's not around anymore. So the court is doing everything in its power to keep her in custody. We're going to see if any of that changes given what just happened recently. Maxwell has requested bail 3 times since she was arrested. She's been rejected each time. In letters to Nathan, her attorneys detailed harsh conditions at the jail, including the constant checks in the middle of the night, which they say are done by guards because the Bureau of Prisons failed to stop Epstein from killing himself in 2019. Allegedly. They also argued she's dropped weight, lost hair, was abused by a guard during a pat-down. Maxwell is accused of grooming underage girls for Epstein to abuse in 1990s and early 2000s. 8-count indictment filed in Manhattan Federal Court. The indictment includes 2 counts of perjury that will be tried separately from the sexual misconduct charges. She's pleaded not guilty to all charges. Trial has been tentatively set for July, which we'll see about that. I'm not holding my breath that we're going to have a Ghislaine Maxwell trial in July. If anything, I think it's probably not even going to happen this year, if I had to take a guess. But I could be wrong. I hope I am, because I do want to see what happens here. We've got Ghislaine Maxwell, another story, says that she uses a sock to cover eyes from the jail guards' flashlights. So every 15 minutes they come, they poke in. She's saying that she cannot prepare for her trial due to that. Prosecutors say those are just routine, but this is the real big story that I wanted to mention. I think very interesting here. The jail guard, this is another story over from New York Post, says that a jail guard stood knee to knee with Ghislaine Maxwell as she used the commode, which is the toilet for those of you here in America. A jail guard stood knee to knee with Ghislaine Maxwell as she used the bathroom in Brooklyn lockup in an attempt to intimidate and humiliate the accused madam, said her lawyer in court papers filed Monday night, last night. The guard team leader at the Metropolitan Detention Center suspected Maxwell of improperly taking legal papers from her attorney, Bobby Sternheim. All right, so pay attention to this name. We're going to go through a letter from Bobby Sternheim after the pair met to discuss her case on Saturday, according to the filing. A group of guards confiscated Maxwell's legal documents, and threatened her with punishment for allegedly taking non-approved papers from her attorneys, her lawyer alleged. So Maxwell was then given permission to use the bathroom where a guard allegedly decided to intimidate her further. Unlike any other occasion, the guard team leader stood knee to knee with Maxwell while she sat on the commode in a small area containing one toilet and a sink, said Sternheim in a letter to the judge. Having a guard standing over her while she used the commode caused her to feel intimidated and humiliated. So that's a whole separate issue, right? You know, a guard standing over you while you're using the restroom. It is humiliating and it is intimidating. And I think that would be the case for anybody. But I'm not even interested in that per se. I am way more interested in this idea that the jail took her legal documents away from her. Maxwell was meeting with her attorney, Bobby Sternheim. Documents are exchanged hands. They take them away from her? Whoa. So let's take a look at this letter that was filed in court yesterday, today, the 27th, it looks like. So you can see here, Bobby Sternheim, okay, as soon as this happened, fires a letter out. This is some excellent legal work I want to show you. Dear Judge Nathan, I write to report an incident stemming from an attorney-client conference with Ghislaine Maxwell. Guards on Maxwell's security detail wrongfully seized and reviewed her confidential legal documents and then intimidated her by standing over her in the bathroom. The incident has compromised her ability to prepare for trial, to confer with counsel, and to retain confidential legal documents. In addition, intimidation and humiliation has further exacerbated her feelings of insecurity due to the power exerted upon her by the guards. On Saturday, Leah Safian, another lawyer, and I attended a pre-scheduled in-person legal conference with Miss Maxwell. The entire 2.5-hour conference was conducted under the constant watch of 4 to 5 guards, including a lieutenant with a camera on a tripod focused on Miss Maxwell and with counsel while recording audio and video and captured on surveillance cameras affixed in the room. After counsel left the facility, Miss Maxwell called me to report that her legal papers were confiscated. This is a big deal, right? If you're an attorney, you have something that's very sacred. It's called attorney-client privilege. All of the conversations, the communications that you have between you, the attorney, and your client, it's so sacred. I mean, you basically die for that. You'll die to protect that. And if the opposing party, the police, the jail, the prosecutors, even the judges, if they get your work product, if they get the secret information that you're communicating about back and forth, that is a breach that is catastrophic, in my opinion. Now, judges and prosecutors, they typically look at it differently, but this is something that is sacred. It needs to be protected. It's your right to counsel. It's something that's enshrined in our Constitution. You have a right to that counsel, and it's a right to a meaningful relationship, right? You don't just get token counsel. Yeah. Oh yeah, you get a lawyer, right? Good for you. Good luck, right? He really works for us, and he's not going to do anything for you because he's part of our government. He's on our payroll, right? You want a legitimate protections for that sacred relationship between defense and your client. Here, that was breached, is what it sounds like. Those were confiscated. Later that day, I received an email from MDC Legal Counsel. So the jail's lawyer sent an email over to Ghislaine Maxwell's lawyer. So once again, let's frame this back out. Maxwell's in custody. They're not going to let her out. Her attorney, Bobby Sternheim, and another lawyer come in and meet with Ghislaine. They're sitting there in custody in a federal detention center, MDC Metro Detention Center, whatever it is, and they're having a conversation. Attorneys leave. They leave documents with Miss Maxwell. Jail guard comes in, says, oh no, you can't have those. That is in violation of protocol. They take those documents away from Maxwell. Attorneys are now home. The jail lawyer emails Maxwell's lawyer and says, hey, just got to let you know, has been brought to my attention by the staff in Brooklyn that Miss Maxwell received paperwork that was not in her possession upon entering the legal visiting area. As you are aware, the policies set forth for Brooklyn legal visits do not allow for the passing of any materials during a legal visit. Due to our policy and procedures, the additional documents that were provided to Miss Maxwell were confiscated. Those materials were put in an envelope and will be returned to you tomorrow upon your arrival at the institution. Please note, you may put these documents in the legal mailbox in the lobby of the East Building. So that lawyer for the jail's, okay, I'm just going to send this email off. Hey, you're in violation of our protocols. We're going to just collect those documents, not going to look at them. We're going to put them in an envelope. You can get them tomorrow. Should be the end of it, right? Oh, okay. Oh, sorry about that. Didn't know about your policies. Didn't know about your procedures. Our mistake. We'll get it tomorrow. Do you think that's what happened? No. Here's the letter that Bobby Sternheim fired right back. Says, I emailed the following in response. Your accusation is inaccurate, as is the information reported to you by your staff. Nothing in Ms. Maxwell's legal papers was given to her by me or by Leah Safian. Both Ms. Safian and I dispute these allegations in the strongest terms. You see what they're saying? You're accusing us of violating jail protocols. Everything has been video recorded, as we saw, right? She said that there are 4 cops there, 4 detention guards there. You're accusing us of bringing in illegal documents and leaving it here. We're not going to let that stand. So they say, both Ms. Safian and I dispute these allegations in the strongest terms. Today, Ms. Safian and I met with Maxwell for a scheduled legal visit under the gaze of 5 guards and a portable camera recording audio and video. After the visit concluded, we left the visiting area. Guards accused Ms. Maxwell of possessing documents obtained from counsel. The guards seized confidential documents from her, including documents she had previously received in legal mail delivered to the MDC and given to her by MDC staff. After seizing highly confidential documents subject to a protective order that your staff is not authorized to review and work product, the guards began reading the documents and have not returned them to Ms. Maxwell. At no time did the guards who were assiduously watching and filming the legal conference bring any concern to my attention, so it is quite telling that you have been contacted when counsel are told that legal staff are unavailable during the weekend. No documents were given to Ms. Maxwell for her retention. Demand is hereby made for an immediate identification of the documents you claim were not in Ms. Maxwell's possession upon entering the legal visiting area in advance of the arrival of counsel. A list of guards present during the visit and a copy of the video recording. Please immediately return the confiscated legal documents to Ms. Maxwell. They are her documents, not mine. The confiscation of these documents has, there it is, deprived Ms. Maxwell of her time and seriously impaired her ability to review legal documents and prepare for an upcoming trial, adding to an already difficult situation. This matter is being reported to the court and legal action will be initiated. Oh, it's beautiful. Oh, it hurts. It stings. If you're that government lawyer on the other end of that, you're going, oh no, what did I do? Because now they got to respond to this. And it's not just this, right? Let's take a quick look and see what else is going on. In advance, guards have gone through her legal papers. In a break from such protocol, the guards did not do so prior to commencement of the legal visit on Saturday. After the legal conference and departure of counsel, the guards seized all of her paperwork. So this is all back to the court now. So what you see here in this document, this is being drafted to the court. Okay, so this they're telling the judge, hey, look, this is what's going on. Then this is the actual email that was exchanged. Now they're communicating back to the judge. Hey, judge, look, also, in advance of previous in-person legal visits, guards have also gone through her legal papers. In a break from protocol, they also did not do so prior to commencement of the legal visit. You know, they didn't check her documents before she went into the room. They didn't do so prior to that day. And so they're making all of these accusations. You can see that this goes on. She no longer feels that her legal papers are safe. She believes that the confidentiality required to prepare her defense for trial has been irreparably breached. You know what this is laying the framework for? They're going to ask to get her out again because they screwed it up, because law enforcement, the prison guards here, breached that sacred bond between an attorney and their client. And now irreparably breached, has no trust, has no faith in the confidentiality of her defense. And now they're going to be renewing another claim. And this is another stake in the ground that they're going to come back to if she is convicted of something. They're going to say, look, well, of course she was convicted. She couldn't defend herself. She had the friggin' government reading her legal documents that were confidential and sacred between her attorney and herself. It's good stuff. Now, it's not just a nasty email. Okay. Do you think that her attorneys are going to just stop there? No, not at all. They want everything now. Yeah. You just accused them of breaking protocols. You think it's going to stop there? No, it's not. So what else are her attorneys asking for? Ms. Maxwell requests the court enter an order directing the MDC through its legal counsel to provide Ms. Maxwell's attorneys only the following information: the identity of the persons who seized the legal material, the inventory of the items seized, a statement subject to penalty of perjury regarding whether the materials were duplicated in any fashion, whether any disciplinary or corrective action was taken against any of the offending guards. So now they're out for blood, right? You screwed that up for our clients. It's not going to happen again. We want blood. We want the person who actually seized those documents. And then we're not done yet, because they're going to send a direct letter now over to the jail itself. You can see here's another letter, Law Offices of Bobby Sternheim, April 26, a notice and a demand to preserve items of evidence. This has nothing to do really with Ghislaine's underlying case, right? Ghislaine's case is about sex trafficking in the 90s and the 2000s with Jeffrey Epstein. Now they want evidence about this interaction. They're sending a demand letter about this little hubbub that happened on Saturday. It says, as counsel for Ghislaine Maxwell, I'm notifying you as legal counsel of the obligation to preserve documents. What do they want? As stated on the April 24th email, all images, video recordings, data files, everything, anything that was captured on surveillance footage. I want names of all guards, including the lieutenant and anybody who's present in the visiting room. Any written or recorded communications, whether stored in electronic, digital, or paper format, obtained in connection. A list of documents that was claimed to be in Maxwell's possession at the time. A list of all documents that were claimed to have been given to Miss Maxwell by counsel for her retention during legal conference. Any written correspondence, blah, blah, blah. Please take adequate steps to preserve all documents, all data compilations, including all electronically stored information. Counsel for Maxwell is going to be seeking electronic data in the custody and control of individuals. And it goes on and on. Please take all necessary steps to prevent the deletion and the destruction of any of this information. Yours truly, Bobby Sternheim. Wow. Right? Opened up a whole can of worms there if you are a person who is a member of that opposing party. If you just received that letter, not particularly good. And so, my friends, that's it for the show today. For some reason, our PowerPoint slides were not syncing, so I don't have any questions queued up. Miss Faith and I are going to figure that out tomorrow, but that's all right because I got to get out of here. I have a 5:30 sharp meeting, and so we're going to button it up right there. As is usually the case, I want to thank all of you who support the show over on Locals. Typically, at the end of the show, we sort of have a little thing that we go through to thank all of our newcomers and anybody who participated and asked questions today. We're going to get back on track with that tomorrow because I got a jet, and I want to just thank you for being a part of the program. Thank you so much for all of your continued support. We're going to be back here, same time, same place tomorrow at 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. out on the East Coast. And for that one Florida man, everybody have a tremendous night. Eat well, sleep well. I'll see you right back here tomorrow. Bye-bye.